Okay, so we're going to start, and Leora, we'll just let you jump in. As usual, everybody, I put a note in chat, and if you'd like to speak or ask a question, just respond directly to me there, please. Okay. Ms. Leora.
Okay. Today I'm going to discuss Chief Justice Rehnquist, the most conservative of the four most recent Chief Justices, I would say. His full name was William Hubbs Rehnquist, and he was a Supreme Court Justice for 33 years. For the first 14 of those years, from January of 72 to September of 86, he was an associate justice. And then for the 19 years after that, he served as Chief Justice from September of 86 until September of 2005. He was the only one of the four most recent Chief Justices who served first as an associate justice. And he also remained on the court till his death from cancer in 2005. So unlike the two I've talked about, there was no retirement. Last week, in talking about Chief Justice Burger, I said that during his time as chief, the court mainly walked in place, neither moving very much to the right, to the left or the right. By contrast, I would say that Rehnquist as Chief Justice oversaw the transition of the court from a liberal court to a more conservative court, although not conservative in all areas of the law. And I'm going to begin with a sketch of Rehnquist's biography, and I'm going to confess that it's longer than the other Chief Justices I've talked about, because I got invested in tracking down some of the details of Rehnquist's life, which seemed to be described differently in different sources, and also because there was considerable controversy over both his appointment to the court as an associate justice and also his appointment later as a Chief Justice. So Rehnquist was born on October 1st, 1924 in Milwaukee, Wisconsin. He grew up in a Milwaukee suburb. His father was a sales manager for various businesses, and he made a comfortable living. So Rehnquist's upbringing, unlike his two predecessors, didn't involve economic hardship. Both of his parents were conservative Republicans, and he very much followed in their footsteps. He attended public schools, and after graduating from high school in 1942, he enrolled at Kenyon College in Ohio. But he only stayed at Kenyon for 1 quarter, at which point he joined the U.S. Army Air Forces, which is the predecessor to the current Air Force. And he was in the military for 3 years. And during his 3 years of service, he was assigned to various training programs, principally focused on meteorology and the maintenance and repair of weather instruments. I have no idea why he was given that assignment, but he was. And for a brief time, he was overseas. He served as a weather observer in North Africa. After the war ended, he resumed his education, this time funded by the GI Bill. Unlike his two predecessors, he attended elite private institutions. He attended Stanford University and completed his undergraduate degree in 1948. He was elected to Phi Beta Kappa, and he graduated with a BA in political science. He chose Stanford, according to a number of sources, in large part because of the weather. His time in North Africa had shown him that there were better climates than he had experienced growing up in Wisconsin and the semester he spent at Kenyon. And so he was looking for a warm climate. He took extra courses while at Stanford, and he received his master's degree in political science in 1948, the same year he earned his bachelor's degree. One of his professors he studied with was Charles Fairman, who was an important scholar of constitutional law and the Supreme Court and its history. And he taught Rehnquist constitutional law in his freshman year of college. And Fairman held the view that the 14th Amendment should be narrowly interpreted in light of its history. And that was a view that Rehnquist shared while he was on the Supreme Court. Rehnquist actually dedicated a book that he published in 2004 to Fairman. After earning his degree at Stanford, Rehnquist spent the next year at Harvard University earning a second master's degree in government. And Harvard is actually where Fairman had studied. While at Harvard, it became clear to Rehnquist that he didn't want to go on to earn his PhD and become an academic. Some part of his reasoning was that seemed to be a place where liberals were more comfortable than conservatives, but there may have been other reasons as well. He wasn't at all sure what else to do once he abandoned the thought of becoming an academic, so he went ahead and took an aptitude test to try and figure out what he should do next. And the aptitude test showed that he had a strong aptitude for law. And so he decided to go ahead and attend Stanford Law School. It's hard to believe that a person would make a decision of that type, a person with so much education based on a test like that, but that's apparently what he did. And it worked out pretty well, as it turns out. He started in the fall of 1949, and he received his degree in 1952, but actually completed his coursework one semester early in December 1951. He graduated #1 in his class, and he was also president of the Stanford Law Review. So his academic performance was much more accomplished than his two predecessors. He and Sandra Day O'Connor, who was then Sandra Day, were in the same graduating class at Stanford Law School, although she started law school apparently a year later than he did, and she graduated in only 2 years. They became friends while in law school together. They studied together. They served on the law review together. They entered the law school's moot court competition as partners, and they finished second in the competition. And eventually they dated. She ended the relationship before Rehnquist completed his coursework and moved to Washington, D.C. To begin his clerkship, but they continued to be friends. While he was first in his class, she was third, and the identity of #2 apparently remains a mystery. The summer before he graduated, thanks to the assistance of one of his law school professors, Phil Neal, who had clerked for Justice Robert Jackson, Rehnquist secured an interview for a clerkship and then the clerkship with the justice. And Jackson reportedly thought that it would be useful to have a law clerk with more conservative views than his own, just as a kind of point of comparison. After Rehnquist completed his studies at the end of the fall of 1951 semester, he moved to Washington, D.C. in early 52 to start his clerkship. By the time he left Stanford, Sandra Day had started to date John O'Connor, who was a year behind her at the law school. And they met when they were assigned by the Law Review to work together on a proofreading assignment. And they immediately became quite inseparable, and they married in December 1952. So why am I including all these details about Sandra Day O'Connor? Because in 2018, a man named Evan Thomas was writing a biography of of O'Connor, and he was given some of her papers, and he discovered a letter that Rehnquist sent to her while Rehnquist was in the first year of his clerkship. And the letter included a marriage proposal. Although I would say not a very romantic one, but a proposal nonetheless. The letter said, and I'll quote from the letter. Second. The letter said, "To be specific, Sandy, will you marry me this summer?" One oddity about this proposal, aside from how it was communicated, is that during the summer, after Rehnquist's second year at Stanford Law School, he was working in the Stanford dorms as a resident assistant. And there he met a woman named Nan Cornell, who was a Stanford undergraduate who was attending summer school so she could graduate in 1951. They started dating, and when Rehnquist moved to Washington, D.C. in early 1952 to clerk for Justice Jackson, Nan Cornell, who had by that time graduated from Stanford undergraduate, moved to Washington as well. And she took a job with the CIA, and in August of 1953, after his clerkship ended, they got married and they moved to Phoenix, Arizona, another place with a warm climate. So the timing of their relationship and the marriage makes the marriage proposal apparently sent to Sandra Day O'Connor in 1952 kind of unusual, to say the least. Whatever the circumstances of the proposal, Rehnquist and O'Connor remained lifelong friends and were on the Supreme Court together from September of 1981 until Rehnquist's death in 2005 at the age of 80. So after his clerkship, Rehnquist moved to Phoenix to take a job with a law firm. For 16 years, from 1953 to 69, he practiced in Phoenix, focusing on civil litigation. And during that time, he and his wife had 3 children, and Nan Rehnquist worked with various charitable organizations. Interestingly, in 1985, the O'Connors also moved to Arizona, which is where Sandra Day O'Connor had spent much of her childhood. And she and Nan Rehnquist, for a time, worked together when they were both active in the Junior League. Nan Rehnquist died of cancer in 1991 at the age of 61. So while he was in Arizona practicing law, Rehnquist also was involved in Republican politics. Among other things, he served as a legal advisor to Barry Goldwater during Goldwater's 1964 presidential campaign, and he helped to write some of Goldwater's speeches. As a pretty good indication of his future views as a justice, Rehnquist urged Goldwater to oppose the Civil Rights Act of 1964 on the ground that the government shouldn't be able to tell property owners what to do with the property they owned. Rehnquist wrote a speech for Goldwater that defended his opposition, and in the speech he said, "It has been well said that the Constitution is colorblind." And so it's just as wrong, he said, to compel children to attend certain schools for the sake of so-called integration as it is for the sake of segregation. That was something from the speech that Goldwater gave. So ironically, this phrase he used, "our Constitution is colorblind," is actually a phrase used in Justice Harlan's lone dissenting opinion in Plessy versus Ferguson, where the court first upheld separate but equal. The phrase has actually been adopted by conservatives on the Supreme Court, like Clarence Thomas, now as a ground for opposing affirmative action, even though it was obviously not originally used for that reason. After Nixon was elected president in 1968, he appointed Rehnquist to serve as Assistant Attorney General in the Office of the Legal Counsel. And in that position from 69 to 71, he served as counsel to Attorney General John Mitchell. In several of Nixon's Oval Office Watergate tapes, Nixon mistakenly refers to Rehnquist as Renchberg. So I don't think they knew each other that well. In the fall of 1971, both Justices Black and Harlan retired from the Supreme Court, and that gave Nixon two court vacancies to fill. Two court appointments to make. He appointed Rehnquist to fill the court seat that had been held by John Marshall Harlan II and Lewis Powell Jr. To fill the seat vacated by Hugo Black. Rehnquist was considered by a number of Nixon's advisors to be quite conservative. But unlike some of the other nominees that Nixon considered, there was no objection to Rehnquist either by Chief Justice Burger or by the American Bar Association, which at that time, unlike now, played an important role in the confirmation. Rehnquist was confirmed by a vote of 68 to 26 on December 10th, 1971, and he began his service on January 7th, 1972. But his confirmation was not without controversy. During the confirmation process, a memo surfaced that he had drafted while he was serving as Justice Jackson's law clerk. The memo was written in 1952 in connection with the court's initial consideration of Brown versus the Board of Education, which the court didn't actually decide that year, but put over for re-argument in the next term. In this memo, the memo defended separate but equal and took the view that the court shouldn't overturn Plessy versus Ferguson. And in the memo that Rehnquist wrote, he said, I realize that this is an unpopular and unhumanitarian position for which I have been excoriated by liberal colleagues, but I think Plessy versus Ferguson was right and should be reaffirmed. In response to the controversy over the memo, and despite the fact that it was written in the first person by Rehnquist, Rehnquist sent a letter to the Senate Judiciary Committee, which said that the memo reflected the views of Justice Jackson and not his own views, and that he had fully supported the decision in Brown versus the Board of Education, but others, including a number of legal scholars, other law clerks who served at the same time as Rehnquist, and Jackson's longtime secretary, a woman named Elsie Douglas, who was long rumored to have a long-term romantic relationship with Jackson, have disagreed with that explanation and have said that the memo certainly reflected Rehnquist's own views. So here I'm going to also take a little venture off to the side to tell you a little bit about the Jackson Douglas relationship, which I never miss an opportunity to add a little show business connection to these talks. And there is one for this as well. So in the year 2000, there was a TV movie, a made-for-TV movie about the Nuremberg trials. And it starred Alec Baldwin as Justice Jackson, and who was the chief U.S. prosecutor at the International Military Tribunal at Nuremberg. And it also starred Jill Hennessy, who played Elsie Douglas. And the film actually had their extramarital relationship as part of its plot line. So apparently this was not a terribly well-kept secret. Since we're talking about Jackson, he was actually raised in New York State, not in New York City, but in the westernmost part of the state. And he is actually the last Chief Justice to be a member of the bar, but not to have graduated from law school, which was possible at a time when you could kind of read for the bar under the supervision of practicing lawyers. He is also the only Supreme Court justice who served prior to his appointment to the court as both the U.S. Solicitor General and the U.S. Attorney General. And he was appointed by FDR in 1941. So now we'll get back to Rehnquist. After he joined the court, he quickly distinguished himself for his conservative views, and his voting record shows that he was more supportive of property rights than he was of the rights of criminal defendants or of privacy rights or in other individual liberties. He was also a believer in states' rights at the expense of the power of the federal government. He dissented from most of the liberal decisions reached by the Burger Court while he was an associate justice. And he was sometimes the only dissenter. And because of that, he was given the nickname the Lone Ranger by his law clerks. And they presented him with a Lone Ranger figurine that he proudly kept displayed in his office. Among the subjects where Rehnquist dissented as an associate justice were cases recognizing the right to terminate a pregnancy, including Roe versus Wade, cases that broadly interpreted the scope of Congress's power to regulate interstate commerce, cases that extended the equal protection guarantee to gender discrimination, and cases narrowly interpreting the free exercise clause or broadly interpreting the establishment clause, such as by striking down school prayer. One of the cases where he was the lone dissenter was Ruth Bader Ginsburg's first Supreme Court victory as an advocate before the court in a case called Frontiero versus Richardson, a case where the court struck down the federal government's failure to provide the same benefits to the spouses of female members of the military as they did to the wives of male members of the military. In 1986, when Chief Justice Burger retired, President Reagan nominated Rehnquist to be Chief Justice. He was the first chief to have previously served as an associate justice since Chief Justice Stone, who served as Chief Justice from 1941 to 1946. And in fact, he was only the fifth Chief Justice to have done so, at least so far, in the history of the court. Rehnquist's confirmation as Chief Justice was even more controversial than his confirmation as an Associate Justice. The issue of the memo that he wrote for Justice Jackson was raised again, and this time Rehnquist was actually even more insistent that the memo didn't reflect his own views, and he testified under oath before the Senate Judiciary Committee to that effect. And he said, "I believe that the memorandum was prepared by me as a statement of Justice Jackson's tentative views for his own use." And he added that the bald statement that Plessy was right and should be reaffirmed was not an accurate reflection of my own views at the time. But he did, however, admit in his testimony that he had defended the Plessy decision in discussions with other law clerks. Elsie Douglas wrote a letter to the Senate Judiciary Committee during the 1986 hearings that said that Rehnquist's allegation that the memo was, quote, about the memo and that it was reflected Jackson's views, she said, quote, a smear of a great man for whom I served as secretary for many years. Justice Jackson did not ask law clerks to express his views. He expressed his own and they expressed theirs. That is what happened in this instance. More recently, long after these hearings, other information has been discovered, which also disputes Rehnquist's testimony and confirms Elsie Douglas, the view expressed by Elsie Douglas and others at the time. In addition, there were other controversies that surfaced during these confirmation hearings, including a second memo that Rehnquist wrote as a law clerk in a different case, which also took the view that's in supporting racial discrimination. This was disclosed, as well as a controversy over two properties that Rehnquist owned that it turned out both contained restrictive covenants in the terms of the sale. And one covenant prevented Rehnquist from selling or leasing his home to Jews, and that was attached to a home he owned in Vermont. And the other prevented him from selling or renting a house he owned in Arizona to anyone who was not white. During the hearings, Rehnquist denied any knowledge of the restrictive covenants. Despite this controversy or these many controversies, his nomination was voted out of committee by a vote of 13-5, and the Senate, which at that time had a Republican majority, also confirmed Rehnquist by a vote of 65-33. At the same time, because there was now a second vacancy, now that Rehnquist had been promoted to fill Berger's seat, there was a vacancy in the seat that Rehnquist previously held as an associate justice. So at the same time Rehnquist was nominated, he also nominated Scalia to take Rehnquist's place. Scalia's nomination was viewed as much less controversial and sailed through the Senate fairly quickly, and they were both confirmed the same day, and they both took their seats on the court on September 26th, 1986. By all accounts, despite his rocky road to the court, Rehnquist was an effective, respected, and well-liked Chief Justice. He was an excellent administrator of the court, and he convinced Congress to limit the mandatory jurisdiction of the Supreme Court so that the justices got to choose most of the cases that they reviewed, something that his fellow justices were very pleased by. Unlike Berger, he was very fair in his assignment of opinion writing. And that fairness also extended to how he ran the conferences that the court held to talk about cases where they'd heard oral argument or decide on cert grants. And he made sure that each justice got to speak once before anyone was allowed to speak a second time. He was also a very down-to-earth and not at all pretentious, unlike the opinion the other justices held of Berger. He had a good sense of humor. He was viewed as very easygoing and not someone that took himself too seriously. Despite his lack of pretentiousness, it's hard to know what the other justices thought of his decision to add 4 gold stripes to the arms of each of his judges' robes, which he did in 1995 after he saw a production of a Gilbert and Sullivan operetta in which the character of the Lord Chancellor, who's the highest member of the British judiciary, wore similar stripes on his robe. And I'll show you a picture, I hope, of the robe. Rehnquist robe, here we go. So here's the robe that he took to wearing on all occasions, not just special occasions, after 1995. I mean, it's possible that it's just a reflection of his sense of humor, but I don't really know. Rehnquist also had an impressive, of course, academic background and intellectual abilities, and his well-crafted opinions, unlike some of the comments about the opinions written particularly by Warren, but also in some parts by Burger, were very much respected even by the justices who very strongly disagreed with him. While he was Chief Justice, like pretty much all chiefs, he engaged in other activities. In his case, he was a legal historian, and he wrote 4 books while he was Chief Justice. He also was the second Chief Justice to preside over an impeachment trial when he presided over the 1999 impeachment trial of Bill Clinton. And he was more qualified than most Chief Justices for that assignment, since in 1992 he had written a book that was called Grand Inquests. And the book was about the impeachments of Justice Samuel Chase of the Supreme Court and also President Andrew Johnson. When he became Chief Justice in 1986, the other members of the court, which I will show you. Here we go. Well, first, I'll show you this picture. This is Rehnquist as an associate justice. I love that, the hairdo in 1972, very much of the time. Oops, I think that's not what I wanted to do. Okay. This is when he was sworn in as Chief Justice. This is his swearing in. It was at the same time as Scalia standing behind him, and Scalia's wife, Rehnquist and his wife, Burger, giving the oath of office, and President Reagan standing behind Burger. So that was the swearing in photo. This is one of his official photos as Chief Justice. And here's the court when he first joined the court. This is the first version of the Rehnquist court. Rehnquist is in the middle. The senior justices at the time were Brennan and Byron White. And then next in order, Thurgood Marshall and William Blackmun. And then in the back row, we have the other justices, Lewis Powell, John Paul Stevens, Sandra Day O'Connor, and then finally Scalia. Sorry. So that was the court when he first joined. The court had some, of course, as they always do, some changes in its membership. And by 1994, this is a picture of the 1998 court, but it's the same justices as were there in 94. And this was the court, one of the most stable a membership on a court in U.S. history. He by 1994, the members of the court were Justice Stevens and Justice O'Connor, the two most senior justices, and then Justice Scalia next in line, Justice Kennedy next to Justice O'Connor, and then the sort of newer appointees to the court, Justice Souter, Justice Thomas, Justice Ginsburg, and Justice Breyer. And of the members of the court that served with Rehnquist from 1994 until Rehnquist died in 2005, there wasn't a single change in the court's membership over that entire period of time. And of these members of the court, 7 of them were appointed by Republican presidents. Only Ginsburg and Breyer were appointed by President Kennedy. So that was the composition of the court for the majority of the time that Rehnquist served as Chief Justice. Sorry, doing this. One other picture that I found, which is a guessing game. Let's see if anybody knows who this is. So this is a picture of Rehnquist in 1996 with with one of his law clerks at the time, someone who has since become much better known than he was in 1996. So here's the picture. Anyone have any idea who this is?
Let's see. Yeah, Judy and Eleanor. So let's, Judy, go ahead, and then we'll go to Eleanor.
I think it's Brett Kavanaugh.
No, it's not. That's a good guess, but it's not.
But I thought
Eleanor,
I thought so also. I thought it was Kavanaugh.
Well, this is Ted Cruz.
Oh, God.
Who was one of Rehnquist's law clerks at the time. I've read that he wasn't terribly well liked by his fellow law clerks, and I guess that's no surprise to any of us.
He was better looking back then, in any case.
Yes, much more clean cut at the time. Okay, so that's the last of the pictures that I have. Over the time in these two periods of time, the early court and later on, the membership of the court became more conservative as compared to the time while Rehnquist was serving as an associate justice. In a number, and the law therefore and the membership allowed Rehnquist to lead the court in a more conservative direction in a number of areas, although not in all areas by any stretch of the imagination. Rehnquist, along with Scalia and Thomas, created a solid conservative block of 3, which you could count on in most cases. There were then 2 swing justices, O'Connor and Kennedy, who often voted with the conservatives, although not in a few key areas of decision-making. So what did this mainly but not completely conservative direction mean in terms of the court's decisions? It meant, as one example, that the court expanded states' rights and contracted federal power. For the first time since the New Deal, the Supreme Court declared an act of Congress unconstitutional because it was beyond the scope of Congress's power to regulate interstate commerce. This happened in a case called United States versus Lopez in 1995. It was a 5-4 opinion with Rehnquist writing the majority opinion, and he was joined by O'Connor, Scalia, Kennedy, and Thomas, as you would expect. And the court struck down a statute called the Gun-Free School Zones Act of 1990. And that law made it a federal crime for someone to possess a handgun near or in a school. And Rehnquist's opinion concluded that possession of a handgun is not an economic activity. And therefore, Congress is required to show the existence of a more direct connection to interstate commerce than in cases where they're regulating an economic activity. And Congress had failed to make the necessary showing, and so the statute was struck down. The court, for very similar reasons, also struck down a key section of the Violence Against Women Act of 1994 in United States versus Morrison in 2000. And Rehnquist once again wrote for the court and was joined by the same four justices. In Morrison, the court ruled that a part of the statute that allowed victims of gender-motivated violence to sue someone who attacked them in federal court was beyond congressional power under the Commerce Clause, and they did so for very similar reasons to their decision in Lopez. The conservative bent of the court also meant that newly recognized rights of criminal defendants, and there were still some, were much less frequently applied retroactively to state court criminal defendants who had exhausted their opportunities for direct appeal of their convictions and lost their constitutional challenges in state court, and then attempted to assert those rights in the process of collateral review by using the technique of filing a writ of habeas corpus in federal court. That was how many criminal defendants asserted their constitutional rights, through the writ of habeas corpus and a suit in federal court. Well, in a case called Teague versus Lane in 1989, the Rehnquist court closed the doors of the federal courthouse to such criminal defendants in a very large category of cases, including most, although not all, cases involving procedural rights of criminal defendants, although not cases involving substantive rights of criminal defendants. But many of the rights in the Bill of Rights that protect the rights of criminal defendants are interpreted as procedural and not substantive rights. This year, in Edwards versus Vinoy, which I'll talk about next week, the Supreme Court further limited retroactivity by eliminating Teague's lone exception for watershed rules of criminal procedure. By far the most notorious Rehnquist court decision was Bush versus Gore in 2000. The case that decided who would be the next president of the United States, a case that President Trump was hoping would be repeated in the 2020 election, but wasn't. In a 5-4 decision with the usual Rehnquist court conservative liberal divide, Rehnquist, O'Connor, Scalia, and Kennedy and Thomas voted to halt Florida's recount, and Stevens, Souter, Ginsburg, and Breyer dissented. The decision was based on the Equal Protection Clause, which they argued invalidated Florida's recount because it was not a recount of the entire state, but only some counties within the state. But the majority made clear that the reasoning applied to the current case, in the current case, would not serve as precedent for future cases, that it was a kind of for this case only decision, which of course further politicized the impact of the ruling. Another quite different but also much criticized Rehnquist court decision was a 1997 decision in a case called McCleskey versus Kemp, which was a death penalty case. It was a 5-4 ruling with Powell writing the majority opinion, which was joined by Rehnquist, White, O'Connor, and Scalia. And it rejected a claim of racial discrimination in the application of the death penalty in Georgia as the basis for overturning a defendant's death sentence. Slight computer problem that I have to fix. There we go. So the claim in McCleskey was based on an overwhelming empirical evidence in a pretty comprehensive scientific study that showed that racial disparity in capital punishment in Georgia depended on the race of the victim and the race of the accused. McCleskey was a Black man who was accused of murdering a white man. The court, however, ruled that racially disproportionate impact, which was shown by the study in the application of the death penalty, was not enough. And the defendant was required to show that there was a racially discriminatory purpose for sentencing him to death in his individual case. Powell argued that the statistical study introduced as evidence in the case should be presented to the state legislature and not to the courts. There were very, very strong negative reactions to the McCleskey decision, and it was called the Dred Scott decision of our time. And Tony Lewis wrote in the New York Times that the court had effectively condoned the expression of racism in a profound aspect of our law. And Adam Liptak reported in a 2008 New York Times article that he wrote that Justice Powell was asked by his biographer if he wanted to change his vote in any case of all of the cases that were decided and that he voted on while he was on the Supreme Court. And he replied, yes, McCleskey versus Kemp. Another quite important area of Rehnquist court decisions, although I think they are in the main cases that it's harder to classify as either liberal or conservative, were a series of cases raising separation of powers issues, as well as one case interpreting constitutional language concerning the qualifications for serving in the House or Senate. So all of these cases kind of involve the organization of our government. One very important case in this series was a case called Morrison versus Olson in 1988, which upheld the Independent Counsel Act. And as you may recall, that was the act which led to Ken Starr's appointment as an independent counsel to investigate President Clinton, which ultimately led to Clinton's impeachment. The court upheld the Independent Counsel Act on the theory that the act didn't increase the power of the judicial or legislative branches of the federal government at the expense of the executive branch. Rehnquist wrote the majority opinion in Morrison, and only Justice Scalia dissented. A dissent that has become more kind of respected over time and may reflect a view of the majority of the justices. This statute expired. It was time limited and it expired, and it's never been it has never been renewed. Another case in this line of cases was a case called Mistretta versus United States. and it upheld the power of the Congress to create the United States Sentencing Commission and to delegate authority to the commission. And once again, only Scalia dissented from the decision. The non-delegation doctrine, the limits on delegation are something that the Roberts Court at least has, some members of the court have suggested it might be wise to revisit. So to revisit a case like Mistretta. Also important in this series is a case called Clinton versus Jones, which was a unanimous decision in 1997 that held that the president can be sued civilly while in office for actions that he took before becoming president. This is something that surfaced during Trump's presidency as well. The case involved a lawsuit by Paula Jones, who claimed that President Clinton had sexually harassed her during the time when he was governor of Georgia. That was a lawsuit that Paula Jones won after the Supreme Court's ruling in Clinton versus Jones. A case which in some ways led to Clinton's impeachment in 1999. The next year, President Clinton also headlined a second case called Clinton versus City of New York, although it didn't concern his sex life. It struck down the line item veto, which had been created by Congress, that the court ruled violated the Constitution by giving the president the unilateral power to amend or repeal parts of statutes that Congress had passed. Typically this was used, or this could be used by a president to refuse to spend money that Congress had authorized in a particular piece of legislation while spending other monies that were allocated in other parts of the law that Congress had passed. So line item veto for a particular item in a series. One final case in this series was the only one out of this line of cases where Rehnquist dissented. And it was in 1995 when the court struck down term limits for members of the House and Senate that had been enacted by Arkansas. And this was a case called U.S. Term Limits versus Thornton. And the court ruled that states can't impose qualifications for prospective members of Congress stricter than the ones that were specified in the Constitution. In some ways, more interesting than the clear Rehnquist court conservative victories were the major cases where the court adopted a more liberal approach with Rehnquist in dissent, and there were also a number of those. One of those was a case I've talked about before, Planned Parenthood versus Casey in 1992, where the court failed to overturn Roe versus Wade, although it adopted a new standard that allowed states to enact more regulations of abortion that would survive constitutional scrutiny. And the outcome in Casey was due to the fact that Justices O'Connor, Kennedy, and Souter wrote an opinion that refused to overturn Roe, but also refused to apply it in its original form and instead adopted an undue burden test to distinguish between constitutional regulations and unconstitutional regulations of the abortion procedure. This year, the court will consider whether it should overturn both Roe and Casey. Um, Two other cases by the Rehnquist court protected the rights of LGBTQ individuals. There was a case called Romer versus Evans in 1996, where the court struck down a Colorado state constitutional amendment that prohibited the state legislature, as well as localities within the state, from protecting homosexuals and bisexuals from discrimination. It found the amendment to be a violation of the Equal Protection Clause. And Justice Kennedy wrote the opinion for the court. And he found that the state lacked a legitimate state interest, since the purpose of the amendment was to, quote, was a bare desire to harm a politically unpopular group. And Scalia and Rehnquist and Thomas dissented from this ruling. The court followed up Romer in 2003, this time relying on the right to privacy, when in Lawrence versus Texas, it struck down state laws that made sodomy a crime, and in doing so, it overturned a Berger court decision, Bowers versus Hardwick. Lawrence was a 6-3 decision. Once again, Justice Kennedy wrote for the majority, and the same three justices, Rehnquist included, dissented. Another liberal victory occurred in 2003 in an equal protection case, when the court, in a case called Grutter versus Bollinger, upheld affirmative action in state university admissions, as long as the university took race into account as one factor among many in its admissions decisions, and did so in order to achieve a more diverse student body. The court, however, did say that the university was not free to use quotas in its decision-making. The decision was one in which Justice O'Connor wrote the opinion for the court, and she was joined by the liberal members of the court, while Rehnquist, Scalia, Kennedy, and Thomas dissented. When it came to First Amendment free speech issues, the Rehnquist court generally protected free speech rights. In 1988, Rehnquist wrote for a unanimous court in a case called Hustler Magazine versus Falwell, in ruling that a public figure, in that case, the Reverend Falwell, Jerry Falwell, could not bring an action, a civil action, for the intentional infliction of emotional distress based on a parody or satire of the public figure that could not reasonably be viewed as a statement of fact. The case involved this lawsuit that Reverend Falwell brought against Hustler Magazine for the publication of a parody of a series of ads that was used by Campari liqueur that in the original ads used double entendre. The ads were styled as an interview with a famous person, and they talked about the first time that they drank Campari, while also suggesting it was the first time, it was a reference to their first sexual experience. And the Falwell parody of the ad published by Hustler Magazine suggested that the first time for Falwell was with his mother, and that was the basis for his lawsuit. In his opinion, Rehnquist spoke about the long history and importance of political cartoons in our public discourse. And he wrote in the opinion, quote, "Despite their sometimes caustic nature, from the early cartoon portraying George Washington as an ass down to the present day, graphic depictions and satirical cartoons have played a prominent role in public and political debate. And he extended that protection to the Campari ad, which in the magazine it was described as basically not true and not to be taken seriously by the publishers of the magazine. So it was pretty clear it wasn't a statement of fact. The court also relied on the First Amendment right of freedom of association to rule against homosexual rights. In 2000, in a case called Boy Scouts of America versus Dole, by a vote of 5-4, the court held that the Boy Scouts were not required to allow homosexuals to be scoutmasters or to take other leadership positions in the Scouts. And Rehnquist once again wrote the opinion for the court, and he reasoned that opposition to homosexuality was part of the Boy Scouts' expressive message. And the Boy Scouts could exclude someone from membership if, quote, the presence of that person affects in a significant way the group's ability to advocate public or private viewpoints. Later on, the Boy Scouts changed its policy. Rehnquist did dissent in one major Supreme Court free speech case. And it was a case called Texas versus Johnson in 1989. Court, by a vote of 5-4, struck down a Texas law that made it a crime to burn the American flag. And it found that burning the flag was protected as symbolic speech under the First Amendment. And Brennan wrote the majority opinion, joined by Marshall, Blackmun, Scalia, and Kennedy. And Rehnquist, White, O'Connor, and Stevens dissented. So a somewhat kind of unusual voting pattern with both Marshall, probably the most liberal member of the court at that time, and Scalia joining the same opinion, while Stevens dissented along with Rehnquist, White, and O'Connor. A First Amendment area where the Rehnquist court was active in changing the law involved the religion clauses. When it came to separation of church and state, the court, with only Justice Stevens dissenting, upheld a federal statute called the Equal Access Act, which required that public secondary schools that permitted extracurricular student clubs to meet before or after school had to also allow Bible study clubs to meet. And that the court ruled that the inclusion of religious student clubs did not violate the Establishment Clause. The court also limited significantly the limits on government funding of religious education. In Agostini versus Felton in 1997, by a vote of 5-4, the court upheld the provision of federally funded Title I remedial education services on site at public and private schools, including parochial schools. And in its ruling, it overturned a 1985 Berger Court decision, reaching the opposite conclusion, a decision where Rehnquist dissented. In 2000, in Mitchell versus Helms, by a vote of 6-3, it allowed the ban. It allowed the loan, of federally funded secular materials and equipment to parochial schools. And in 2002, in Zellman versus Simmons-Harris, it went further in a 5-4 decision, and it upheld a voucher program that provided state money to help students pay tuition to attend private schools, including parochial schools. In Zellman, Chief Justice Rehnquist wrote the majority opinion, and he relied heavily on the fact that the students and their families were making private choices of which school to attend and not the government making the choice for them. But the court didn't go as far as Rehnquist would have liked in lowering the barrier between church and state. By a vote of 5-4, the court struck down prayers at public school graduations, even when they were delivered by a member of the clergy and not school personnel, because the court found that there was state involvement in inviting a member of the clergy, in this case a rabbi, providing a place for prayer in the graduation program, and giving the rabbi guidelines for prayers to deliver on civic occasions. Kennedy wrote the majority opinion, and Rehnquist, Scalia, White, and Thomas dissented. The court once again extended the constitutional restriction on school prayer in 2000 by a vote of 6-3 when it invalidated student prayers at school football games. Once again, finding sufficient government involvement. Rehnquist wrote a dissenting opinion joined by Scalia and Thomas. The court also extended free exercise rights in a number of cases, but one of its decisions interpreting the free exercise clause has since become controversial. In Employment Division versus Smith in 1990, Scalia wrote an opinion which Rehnquist joined that upheld the right of a state to enforce its prohibition against the use of peyote, even if it was being used in a religious ceremony. The state could, if it wanted to, exempt a religious use, but it wasn't required to do so. Smith applied a minimum scrutiny test, easy for the state to satisfy, to uphold the uniform application of Oregon's drug laws. But it did describe a whole raft of cases in which strict scrutiny would be appropriate, harder to satisfy, and very difficult, if not impossible to satisfy standard. That standard would be used if the law discriminated against religion, or if it wasn't generally applicable because there were exemptions available, but not a religious exemption. Recently, the court has been asked numerous times to overrule Smith and apply strict scrutiny to all cases in raising free exercise claims. But thus far, the court has avoided deciding the fate of Smith by always managing to find either that the law discriminates against religion or that there are exemptions available. So there are many other important cases that I could talk about, too numerous to name, but I've kind of run out of time and energy, and I want to answer some questions if there are any. Next week, I'm going to talk about the current Chief Justice, John Roberts. So we'll see another transition, series of transitions on the Roberts Court.
Well, Leora, we've got the time if you've got the energy, but that's up to you. If there are any others you want to, question in my mind, and I'd love to hear from other people too. Do you feel that Rehnquist was pretty consistent in his views, or did he go back and forth? Generally conservative, obviously, but sometimes not. And how would you explain that?
No, I think that Rehnquist was fairly consistent in his views. Certainly, as yes, he had an existing constitutional philosophy when he joined the court, unlike the previous two chief justices who really didn't have a fixed view of the Constitution. I think Rehnquist developed one, starting with taking his freshman course in constitutional law with Fairman, a great scholar of the Constitution, and continuing through his law school experience and thereafter. He was much more of an intellectual than the previous two, and he therefore did have a fairly clear constitutional philosophy. It's unusual that someone would have such a philosophy who had never before served as a judge. Mostly now they pick people who've served for a long time on a court of appeals so that they've had a chance to develop a philosophy and you can tell what you're getting, unlike in the case of some earlier appointments. But Rehnquist did, I think, have such a philosophy. I mean, you might say not every decision was, consistent, but I think, he could explain them in ways that, make perfect sense. I mean, the flag burning case, for instance, that was an unusual decision because a number of justices who dissented on the grounds that the flag was a unique symbol, different than anything else, any other way that that the country had of acknowledging its existence. It wasn't like a copy of the Constitution, or it wasn't like that. It was unique because countries are known by their flags, and therefore there was more power to protect the meaning of the flag than there was any other symbol. Now you could disagree with that, but Rehnquist would say about that, I'm not saying that any of my other views about the First Amendment are wrong. I'm only saying that here we have something quite unique. And he wasn't alone in taking that view of the flag. So I think, yes, I think he was pretty consistent, more so than most members of the court. Well, he wasn't trying to sell this house. This was a house he bought. And the terms of the sale, when he bought it, contained this restrictive covenant. And his view, he would basically say, look, I didn't read, the fine print in the sale document. I'm sure if anybody's bought, property, they probably didn't either. I don't know for how long. It could have existed since the property was first developed, as is true, in a lot of these cases. The Supreme Court has struck down before Rehnquist restrictive covenants in deeds. So these are unconstitutional and no longer enforceable, but they still actually exist in numbers of cases, particularly in the South. There are terms of sale that still include restrictive covenants, even though they cannot be enforced. They've just never been removed through any kind of formal action. Okay. It would take some kind of modification of the contract, and and that just hasn't happened. So it wasn't that he was trying to sell the property. It was that it was discovered, what this document contained, because people were, kind of looking very carefully at everything that Rehnquist had ever done during his lifetime, to see if there were any grounds for objecting to him becoming Chief Justice. And this is, one of the things that was uncovered, and journalists were obviously doing the same thing. A lot of this information came through journalists who were researching Rehnquist. So that's kind of, it wasn't really that he had tried to do anything with the property.
Okay. So, I have a question, something you were talking about beginning of the class about did Rehnquist really support separate but equal, and the memo, and he said, no, this was Jackson's view, not mine, and it was very controversial. It sounded to me, as you were telling it, but maybe I got it wrong, that he was, let's say, fibbing, and perhaps he did support separation. Do you have any thoughts on that?
Well, there's a lot that's been written about this, and a lot of people say that he was lying, and there's a lot of evidence that was the case. I mean, it's known that Jackson had a general policy of not asking the clerks to reflect his views, but only asking them to reflect their own views as general policy. There are other reasons, things that he said to, other clerks, etc., that seemed to suggest that that was true. There was of course, his longtime opposition to civil rights laws, which, could also suggest that he didn't disagree with Plessy. But on the other side of it, there was the fact that originally, when the court first discussed deciding Brown versus the board, Justice Jackson took the view that he was not prepared to overturn Plessy, I think mostly based on a stare decisis theory, that it was a precedent that he couldn't justify overturning. Jackson eventually changed his mind, which led to the unanimous decision in Brown when Warren became Chief Justice. But some people say, well, initially that memo is consistent with Jackson's views. Other people disagree with that. So like a lot of history, there are things pointing in opposite directions, and I guess we'll never exactly know, but it does seem to me that there's certainly a history of Rehnquist denying things that make him look bad. But who knows? I mean, there's no general sort of view that he was dishonest in any way, and he certainly didn't conduct himself as chief in a way that made the other justices think that was the case. So hard to know.
Yeah. I also had a question about Bush v. Gore and the decision, which obviously had momentous implications, consequences in the U.S., and Gore didn't fight it. Was the decision in effect saying, well, if they had recounted the entire state, that would have been fine? And was it too late to recount the entire state?
Well, there was certainly, I think that is, part of the decision. There were numbers of threads for the decision, so that you couldn't exactly, pinpoint, the court on every nuance. But there certainly was a notion that if there had been a statewide recount using uniform standards throughout the state, and if that had happened in a timely manner, which it really couldn't by the time the case reached the court, it was pretty much the deadline for a recount. And they actually decided the case, I think, at the deadline, but they acted very quickly. I mean, practically, in the blink of an eye. But it was still too late to make the safe harbor deadline by which states are supposed to resolve election disputes. Now, the court, could have, and so they kind of relied on the safe harbor deadline. The court could have said that a state could extend that deadline and still, deliver its votes in a timely fashion to Congress if they'd been of a mind to, but they didn't, and they didn't have to face that issue because they simply said, really relied on the existing safe harbor deadline, and therefore it was unconstitutional. So they weren't interfering with the state's ability to hold a recount. They were only interfering with the state's ability to hold a recount that is a recount of only, some counties in the state. When you think about it, it's an interesting decision in light of Arizona's current recount of only a single county within the state of Arizona, which has now been going on for about 4 months or so. If somehow there was some dream that a recount at this point would be able to change the outcome of the presidential election, I think that that would certainly be inconsistent with the decision in Bush versus Gore. So I guess there's kind of a silver lining to everything.
Yeah, right. So what is your own personal feeling about him? I don't mean do you like him, not like him, but as a constitutional scholar, do you think he was one of the greats or one of the minors, or I mean, where would you place him?
It's kind of hard to say. I mean, that's something that people who really study the history of the court, in a consistent way, which I don't consider myself to be a legal historian or a constitutional historian, I mean, and I never taught legal history classes, at the law school. And this, actually, I think I said this last week, this kind of experience of looking at the court this way, is a really eye-opening one, something I really had never, done before. And I don't really know in what ways it will, ultimately change the way I think about things, that I've now, got yet another new perspective. I mean, I think that there's no doubt that, Rehnquist is quite a respected scholar. Some people have claimed that he's one of the great justices. I mean, that's a pretty high standard. There've been a number of great justices, and I don't know that, I necessarily put him in the pantheon, but he's certainly, highly respected as a scholar of the Constitution. And he didn't engage in sloppy reasoning or any of the other things that justices get criticized for. And he was himself a legal historian, having written this series of books, one of which he actually dedicated, I don't know if I mentioned this, dedicated to Fairman. And, he was obviously a very, very smart man. His academic record speaks for itself. You don't get that kind of academic record just by hard work. You've got to really, not through those levels of schooling. He excelled, in every way you could imagine. So he was very smart, and he was, hardworking. And he produced a considerable body of decisions, of important decisions. But I'm not very good at, kind of ranking the best. I might be able to rank the best on a particular court. Give me the current 9. I'll maybe could tell you who I think is the best, and certainly who I think is the worst. But once we have to go over the centuries, from the beginning, I don't think he was as important as John Marshall, but he made an important contribution. Ideology,
Not necessarily
one I
at the
agree with, but and I think he certainly would rank, in a list of, I don't know, the top 15, maybe the top 10, I don't know.
Okay, not bad. I thought, we had talked in previous sessions about friendships on the court, and do people like one another, or do they at least respect one another, and how important that is. But I think this is the first time you've talked about people dating. So
Right.
I want to thank you for the People magazine version of your class, but
Yes.
their relationship is very interesting, because they didn't always agree, but as you said, they stayed friends, and seemed
Yes,
pretty
they
remarkable.
Yes, well, but look at Scalia and Ginsburg. I mean, and even a more unlikely friendship. And they were very, very close friends, and their spouses, and they, socialized all the time. And so, I think that the justices are, if they have the right personality, they're perfectly capable of separating their views in, cases that the court resolves from their views, about the character of the justices that they sit with. And there are many, many examples of, it's kind of what we call strange bedfellows, among the justices who, were personally friendly, even though they did not share a view of the Constitution. I mean, so I don't think it's, so surprising that we would have that. But it is true that this is the only romantic relationship that anyone knows about. And
The only literal bedfellows. Okay.
right, literal
Perhaps.
bedfellows. And it's certainly the only parent marriage proposal, though I still find that a little mysterious in the story as it appears. But it's almost like, I mean, I hate to say this, but it's almost like Rehnquist had decided the time had come for him to marry. And his first choice was O'Connor, but if she didn't agree, then he had Nan Rehnquist as a backup plan. But, maybe that's a little contradicted by the fact that Rehnquist, in an interview later in his life, said that Rehnquist said that Nan Rehnquist was the only woman he ever loved. So, who knows? Of course, he could have, convinced himself of that over time. Who knows? Fact that for many, many, many years, members of Congress, crossed party lines to develop friendships, really did work together. That's kind of disappeared as we become more and more, the partisan divide has broadened, and obviously it produces deadlock. I mean, Congress does very little compared to what it used to do. And a whole bunch of other very negative consequences that are, putting democracy at risk. Yeah, no, they're used to, and the friendships were very important, actually. I mean, unlike on the court, I think, where the friendships were separate from their decisions, right? The justices were capable of understanding, this is my opinion that I'm writing, this is my friendship. I think in Congress, where there isn't that same line, the fact that there were friendships that crossed party lines made it much more likely that the members of Congress would be willing to work together to find some compromise in legislation that they could all support. And so, it was even in some ways more important than the friendships. I think actually in every way more important than the friendships among the justices. It is a good point.
Well, and Biden talked about that during the campaign about friendship, and he got in trouble for talking about being friendly with, I believe it was Strom Thurmond, who was a out and out segregationist. And certainly the fact that so much is polarized and Congress doesn't meet and people don't drink, or you almost wish people would go back to drinking. But just one last comment from me, and if you want to tell us about next week, which is the proposal he sent Sandra Day O'Connor, where he said to be specific, and I thought, do you have a general proposal as opposed to a specific proposal? I mean, it was really funny.
Okay, so the answer is that in the stuff I read about this, one piece describes the fact that there were two letters. And the first letter said, we have to talk about something important. And the second letter contained the proposal. But another piece I read, and this makes more sense, but I didn't want to include it because I'm just not sure, suggested there was one letter. And the letter said, there's something important I want to talk to you about. And then went on to the proposal.
That's a better.
Would,
Okay,
I mean, even so, it's not terribly graceful, but at least it, has some kind of intro to be specific. Yeah. I mean, not much of a romantic, I would have to say, by the phrasing of the proposal.
So we are right at noon. We need to wrap up, but do you want to give us a quick preview of next week? And of course, it'll be in the email reminder going out on Friday.
Yeah, I mean, I think, we've been talking about the Roberts Court, for a long time. I mean, pretty much all the decisions I've talked about recently, all the developments, and we're going to kind of, I'm going to look at John Roberts as Chief Justice. He's, of course, as we know, had, unlike Rehnquist, has had a court with a quickly changing ideological composition. It started out with Roberts to the right of the court he inherited. It then came to a point where Roberts was the median justice, the guy in the middle after Kennedy retired from the court. And suddenly, Roberts was the go-to guy who really was the deciding vote in a lot of key cases. But that swiftly ended till we find ourselves in the current situation, which the court has moved farther right than Roberts is comfortable with in a lot of areas. And so, exists a pretty strong conservative majority, even without him, although not on all issues, which has, although that majority is not always in agreement on all issues, or their rationale is not always the same. So, we have a lot to talk about because of this, complicated series of transitions that's happened, during his, time as Chief Justice. And of course, he's likely far from finished with his time as Chief Justice, given the age at which Chief Justices have tended to retire.
Right.
And so, we don't know the end of this story. It's the only one of these four where there's not an end game yet that we can talk about.
Okay. A cliffhanger. Okay. Well, listen, thank you as always. Really interesting and insightful and fun. Okay. We thank